Thank you. Good morning. I hope you are fine. My name is Jan. I'm attorney at law. I'm a lawyer, so be kind to me. I'm here to present to you the topic that we have and the presentation that we don't have. And we can discuss data and databases and data sets. Data is one of the most important things in the current world because the world is flooded with data. Data are everywhere, well, is everywhere. Data is everywhere, around us, in your mobile phones, on the internet, basically everywhere. And the interesting thing about data today, that it's the gold of this age, it's the oil of this age. It's one of the most important things in the world that everybody uses, and there are many companies that produces data, there are many entities that produce data, and everybody uses data. But the important thing is, can we use these data, and for what purposes we can use these data? So my aim today, which I believe we can discuss, is what are the basic legal problems with data, and we can also take a look at the practical side of the thing, and how you can use the data that you maybe find on the internet, that you maybe find basically anywhere, and what are the problems that you can face and how to deal with these problems. And of course, if you have any like personal problem, well, like meaning with the data, well, we can discuss anything. So you can ask right away and we can take a look at it. We will have at the end of this session like quite a time to discuss it, so feel free to ask. Well, so basically we have some terms, of course, and which is a data set, database, and there are some individual items in any database or data set. So what's a data set? Does anyone know? I will give you like score points for every good answer that you will give, and at the end you will receive some award from university. So what's a data set? Does anyone know? Yeah, I don't know as well. I don't know what's a data set, because there's no like legal definition what's a data set. So this is some words that we use, and we think that most of us feel that a data set is a database. I believe that if you see, so that's the main thing that maybe comes on your mind, but basically data set has no real meaning in law, and for us the important thing is database. And what's database? It's a set of data, of course, but it must have certain quality to be used. So dataset may be, for our legal perspective, as a set of data, which is of course a very stupid definition for me, but basically dataset is a dataset and it has no real meaning in law. So what you will hear, because this session was about to be about the datasets, but we will focus more on databases, which is very, very tricky thing. And there are, of course, some items. So if you have a database or a data set, there are some items in the database. Do you think does it matter what items are contained in the database? Of course. Yes, of course it matters. And there may be databases which are filled with personal data. Everybody loves GDPR. I personally have a tattoo GDPR on my back. So everybody loves GDPR and things like this. But there can be also other data contained, like trade secrets, perhaps, some information about business, or some, I don't know, telemetry data, a lot of other data. So we can have several types of data in the database. What's the tricky thing? That we, from the legal perspective, have two types of databases, which we will discuss. The first one is a copyrighted database, and the other one, the more important, is sui generis database, protected databases, which you will see as a SGDR lately. So wherever you see SGDR, so we will discuss these things. The other issue we have are that as you are probably aware, if you want to use something, you should have a right to use it. So we will have some licenses that are used for database licensing. And of course, these licenses are of different kinds and have different conditions, and we will discuss the differences between them and which you should use and which you should not use. And of course, we will discuss some data mining principles and EU AI and other things that we have today. So here are some crucial terms that you have. So as we said, the data set doesn't mean anything in our legal way, but we can understand it as any structured collection used for analysis, model training. That's a practical definition, not like a legal one. But what is more important is the database, which you can see it's a collection. This is the important thing. It's a collection of independent materials. So once again, you have individual items collected together, and they are, once again, important thing, arranged systematically or methodically and individually accessible. So can you give me an example of database?
PDF4.
Cool. Any other? So it's like perhaps a commercial registry database. Yes? Yes. Come on, guys, it's morning, I know, but you know. So is information how the weather was yesterday for last 50 years a database? I believe that it is. Is my Facebook or Tinder friends collection a database? It is. Is Helena Vondráčková best of CD containing all her best song a database? Who thinks that yes? 3, 4, 5. Who thinks that no? Who thinks this is a stupid question? Okay. Who thinks it's a good question and tricky question because it's put in this way? Yes, it's also a database because it's a collection of independent materials arranged systematically or methodically and individually accessible. If you have a best of CD, it's sort of a database. So you see these databases can vary in many ways. And for your scientific and technical purposes, you are usually accessing databases that contain data of some outputs of perhaps some researches, or there are some organizations producing these data, or government producing these data. So it's large files usually that you can use. But anyway, this is a legal thing, so this is a database. And if it does not meet the legal definition that we have today, so then all the laws does not really relate to these databases. Well, and in the databases, there are, of course, some individual items, like temperature, pressure, moisture, perhaps personal data, names, dates. There are some individual items. So, and are these items protected in the database? Can I use a single item in a database without anything? Who thinks that yes? No. Who thinks that no? Yeah, mostly. Who thinks it depends? Yeah, of course, it depends. It depends. So there are some items that are protected, like personal data. Of course, the GDPR still rules over all of us. Or there can be some information that you can use however you like, and we will also take a look at it. So if you want to use a database, always take a look what kind of database it is, who is providing it, and what are the items contained in this database. As I said, the law that we all love distinguishes two types of database. The first one is a thing which is rare and which is called cooperative database. What is it and why is it important for us? I don't believe it's much important for you, because in these kind of databases, the key is there is someone who uses his skill and wit to create this database to be original one. As I said, the best of CD of Helena Vondráčková is a database, so there must have been someone who really loves Helena Vondráčková and knows all her songs that much, and he's able to select the best 40 songs and put it on a selection. So this is a database of the best songs of Helena Vondráčková, and it's my unique selection. So this is or if you have a best of Pablo Picasso's works, if you have a database of these works, so someone must have done this mental approach and said, these are the best pictures of Pablo Picasso. And this is a database which is copyrighted because it's a unique selection of something. It doesn't have to be music or art or whatever, but it's a unique selection. It's an art, sort of. Well, basically, for your purposes, these databases does not make much sense because usually you want a great data sets of everything. So these are protected the same way as you protect art, music, software. These are the copyrighted database. The other thing that the law says, okay, we don't have much of these databases, so can we keep the status that someone really gathered much data, organize it, make it accessible, and we will have no protection for these databases? And the law says, nay, that wouldn't be fair, because if you had so much effort to create something, you should receive some protection. It's just fair. So we created the sui generis database, right, as GDR, and it says, if you provided some substantial investment in obtaining, verifying, etc., some data, this right is given to you. So you have gathered some information, you produced, you spent some money, you paid some people to collect these data, I put it all together in the data set. And you are provided with this right. And what does this right give you, this right? Any idea? What's the most, so if you paid some money to create a database, the most important right that you have is that you can decide who can use this data. Quite simple, I know, but it's important because otherwise you would not spend money to create a database, because otherwise you would create a database, put it somewhere, and somebody scrapes it, use it without your consent, which never happens. But you have all legal right to perhaps you to file a legal action against somebody who uses your database without your consent. So the world has people who invested and created these databases, and he holds this right, which gives him power over his database. The right lasts for 20 years. So you're saying, so if the database is older than 20 years, I can use it? This right ceases to exist? That looks really dull, because basically if you make a reinvestment, if you update the database, if you improve it, the right is like renewed. So new 20 years is going, and new 20 years going after every significant improvement of the database. Which means that this law may technically never lapse, it may never cease to exist. There are, of course, legal exceptions how to use databases which are protected. So most databases in the world, in European Union, that's what I'm talking about, is European Union law. It's European Union law. If you go outside the European Union, what can you find? Something else. You know, this is EU thing. So in some countries, you may face very different approach, especially in the United States, where they have completely different approach. But here in European Union, this is what we believe exists, and it works like this way. So to make a short summary, if you find a database, probably this database is protected by this right. There was an interesting thing in law when Ryanair, everybody knows Ryanair, it's when you're put in a box in the plane like this and you travel somewhere and you're having fun because it costs you only 200 Czech crowns. So that's Ryanair, and they produced, I believe it was Ryanair, anyway, they produced the number of their flights, and somebody wanted to use this database of the flights for some purposes like Kiwi or these kind of Skyscanner services. And they wanted to use this database, and Ryanair said, hey guys, this is our database of our flights. You cannot use it because we are the database right holders. And the court says that this database is not created by the substantial investment in obtaining, etc., because you're creating this database by your activity, which is like your substantial activities. You're doing flights. So you have your information about your flights. This is nothing extra that you do. And this is important. If this right should be created, you need to do a little more extra. It's just not created under your plain activities. So the airlines, they lost the case because there was no substantial investment. They just said, we're flying this and that. And you cannot prevent other people from using this data under this right. It has a solution. I will show you how to do it if you have your database right. So what's the result? If you find a database, you cannot use it just like that. So what is not protected? Well, just the raw facts and the raw data like daily news, etc. These things are not protected. Non-original compilations like in creativity and substantial investment. So these are not protected. How can you tell whether the database is protected or not? Is there any, trick how to say this database, yes, it's substantial, this is not substantial, this is original, this is not original? How can you tell? By nature of the content. The right question is that you cannot tell. And you may feel that this is so significant by the nature of the content, how it looks, but the safest way that there is some legal notice there saying this is protected by something, these are the rules, how can you use the data? Because this sui generis database law, it's not written anywhere, it's just created, it's like authorship. It's created here in Europe, like, it's just created. Suddenly my database is protected. But this uncertainty that you have about databases is something that you don't want. If you want to use any data, you must be sure what is the regime of the data. If you see a database and there is nothing there, and you want to use it for your scientific purposes, for commercial purposes, so then if you don't know the legal background of the database, you are a potential client. So you are because then you might be in some trouble and you might not know. So using databases of which you are not sure what's the legal regime is very tricky and very risky, and I would never recommend to use it. One of the most common mistakes about databases and data in general is that if it's public, then it's free. That's the first thing. Well, okay, it can be public, it can be free. And if it's public, then I can use it. I found it on we're in 2025. I know it's shocking, don't worry. We're 2025, so the internet is not new for some people. So most of us now understand that if it's on the internet, it doesn't mean that you can use it without like any restriction. So publication does not create any waiver of rights. So if I put my database online, it's there, doesn't mean that everybody can use it. And if you said, I found no legal notice there, and it's free online, I can access it, so I see no restriction to use it. Well, that's a mistake. If you see no restriction, doesn't mean that the protection is not there of the data. As I wrote there, of course, if the database that you want to use contains personal data, GDPR is holding the flag over the database. So what's a personal data? Is my name personal data? Really? Jan Barta, do you think it's that original? There was a Jan Barta speaking there. Would you know? If I was François Kozíšek, maybe it would be that original. But I believe, sadly, that my name is not that original. Thank you, Father, Mother. So Jan Barta, well, maybe a lawyer focused on IT law. Who else but me? Yeah. But yeah, it could be my birth name, my birthday information. So basically, personal data are any data that allows you to connect these data with an individual. This is a personal data. So a collection of telephone numbers, just the telephone numbers. Is it the personal data? Could be. Collection of ID of your car, of vehicles. Collection of just these IDs can be a personal data. The court says yes, because the car, it can be connected to an individual. And you can go there. So what if you see a database which contains some codes, like 1, 2, 3, 5, C7, it's like a lot of numbers, and there are perhaps temperatures connected with these numbers. Is such a database personal data? It's like 1, 2, 3, and that's 25 degrees, and then it's 4, 7, 8, and there is 13 degrees, and you have a database of such numbers. Is it a personal data? You don't know. That's a perfect question. I always love this answer. We don't know. It depends. Who's looking at these data? Because someone can know that these numbers are connected to some people, and this is the temperature, how stressed they are at this session, perhaps. And you can use this data. So this is something that we called pseudonymization. I hate this word, never able to tell. Or they are anonymized, but it depends. So you need to take a look at every database that you see, whether it can be a personal data or not. And if it is, you need to follow GDPR. We will take a look at the GDPR later a bit. The other thing that is also important if you find a database that you can use are the terms of use. What's the terms of use? Well, it's a contract. You know, it's a public contract that is on a web page usually that says what are the terms how you can use the database. And we will take a look at it because this is very important. So basically, if you find a database, you don't know if it's protected or not. This is the tricky part. As you see, the sui generis right to databases is sort of a tricky question because you never know whether there is some substantial investment, whether the database is really that strong enough to be protected by law. So what do the database creators do is that they create licenses. What's license? License is a right to use something that's not yours. It's a license. What's a cool thing about the license and this regime is the thing that I don't care whether my database is that good enough to have this sui generis right, whatever. I don't care about this thing. I don't know, too much love for me. So what I will do is I say, I offer you to use my database under these conditions. And here's a license they are offered to you, and you must follow this license to use the database and the data inside. So it's sort of a contract. So imagine a database of Ryanair flights, perhaps, that we said it's not protected by a special database. So what if this airline put on that page terms and conditions of use of this page, which will say, you can use this database only if you fly by Ryanair 7 times a week and other conditions. Would it be valid? Well, possibly. It's a contract. So I have something, and I agreed with you that you will use it under these conditions. If you don't want it, your problem. So under the contract, you can very effectively regulate anyone who will access your database and use your data. And you can have a really zillions of options how to use the database. And it's basically up to you. So that's why I really said it's important, if you find any data on the internet or anywhere else, to take a look at those stinky legal documents, which will be very uneasy to read usually, and take a look how can you use the database as a whole or parts of the database. And this approach today is far more important than any sui generis database rights, because it's just a fair contract that you can read and use. So what are the basic licenses that we use? Well, there are basically 2 approaches. The first one is that we called proprietary approach. It means that you basically want to sell the database or sell the content of the database, which usually says, pay some money and access the database. Fair enough. But usually there are some restrictions. So is there any database that you use under commercial approach? Do you pay for access to any database? Journals? Cool. It's a very good database. We've created some content, which is spread it somewhere, and then you can pay some paywall, and then you can access some database of something. It's copyrighted stuff. And the journal as such is a copyrighted work as such. So we have a database contained with other copyrighted works, usually. Okay, anything else? Only journals? There's tons of paid services that you can use, that you want to access, basically. Usually, these services are regulated in a matter, perhaps pictures. Very often, we meet in practice that some client of ours comes and says, hey, I received a letter, and the letter says, you have used a picture to support your article, and they wrote to me that you have no license to this picture, but I use it, it was free on the internet somewhere. I Googled it on a page which said, free pictures for everyone, and we take a deeper look at the conditions, and these conditions says, yes, it's free if you want to use it at home for your Christmas cards and for your birthday invitations, but if you put it commercial or for scientific or other purposes, you need to pay. The condition, it's free, but it's not free for everything. So these databases and access to the database can be paid, usually by some subscription. You'll pay some money to access it. And then you can pay, of course, for individual items contained in these databases, like articles, journals, pictures, software, many things. But the one thing is that you need to pay for accessing the database, and the other thing that you need to see what are the conditions of using the individual items of the database. It means that you can pay for accessing the database, but you can also pay for the individual item, and you need to very carefully read those terms and conditions, whether it works or not. Because it's a very unpleasant situation that you perhaps used some content and then you spread it all over the world, and then you see that it was not so free as you thought because you haven't read those terms and conditions that you have there. And of course, the rights holders would like to go for you. Has anyone ever received such a letter that he's infringing any rights? Like using a picture somewhere that you just download it and Googled, or Googled and download it, which is usually the way you do it. So don't do it if you use it like in a commercial way. Well, the world is not that bad always, and not everyone wants money. There are some people who doesn't want money. Of course, there are some databases which are produced by government, which now the Digital Government Act and the Data Act forces some institutions to create data as open source, as open data, which usually you are free to use. But the world created several, as we say, open licenses, which is the world of Creative Commons and open database licenses, which are standardized. So there's no need usually for long terms and conditions, but you will only see very small links like saying like it's CCO or CCBY SA, which is not a Nazi organization. SA, it's a share alike abbreviation. PDDL, ACDC, no, it's not AC, you know, these things, BDSM, all these kind of things that you can see on the pages. So if you see these abbreviations, these small things, that it means that there is a standard license applied to this database, standard license, which is important because this license, if you're creating something, you may use different sources of your work with different licensing, and not all the licenses are compatible. Not all of them are. Some yes, but some no. So let's take a look at these very standard licenses. What do they mean, and how can we use it, and what are the tricks? Yeah, I will go to that later, so let's start with these. So this is CC BY 4.0 license, quite common one. Wikipedia uses it, quite. So if you, there's an attribution. There are, like, the first thing that you need is attribution. It means that you need to cite who holds the copyright and what's the license terms. So this is like example attribution, all of these. You will receive the presentation. Yeah, so you don't need to write everything. We will give it to you. If you pay, no. It's a database of our office. So this is a quite common one. So you can see that this license means that you can, it's a free use of the database. It's important, it's free. So you can copy, share it, modify it, use it commercial, whatever you like. You can combine it, but you need to make the attribution and indicate if you made any changes. And you cannot restrict your rights. So you cannot say, if you use this license, that like you need to pay for this. No, because the people who created the databases want it to be free. They want it to be known. So you cannot say, I restrict the access to this database. So this is a really cool one. This is a really cool one. But now let's see the trick. So let's add two letters to it. SA. As I said, it's a share-like. It's very, yeah, it's easy. That's not much difference of it. It's very easily to overlook it. And it's completely different type of license because the SA, the share-alike, means that if you create anything under this database, so if you mix it with other data, so all these outputs must be licensed under this license. We call it copyleft. You know copyright, right? It means that it's protected. But what copyleft does is that if you use a copyleft component in your work, that everything connected with this component must be also copyleft. And copyleft is free to use, etc. That technically means that you have created something unique and nice that you want to protect. But if you create it with the use of a copyleft source, then everything must be further licensed under the free adapt, share, modify, whatever. Which means that you will lose your right to restrict access to your work to other people because you used this copyleft thing. This is very important if you perhaps creating a software component. There are many software components under these licenses, and it technically means that if you use a software component or database component under this and create perhaps a computer program with these components, that the computer program must be free. Which is a horrible way if you put much effort in creating it and you must have it published, etc. So this share-like condition is a very tricky one. Of course, if you don't care, there are many sources because these databases were created by people who believed that it should be free, it should be always accessible, it should be for the benefit of the all humankind. And who are you to say to them that you will restrict it? So you will find, sometimes you will say, this is cool, this is so good, it's everywhere, everything is there, but you know that if you use it, then if it's Jane Doe said it, that you cannot exclude that share-alike copyleft matter. Have you ever witnessed this? Have you ever found? Someone say yes, yes. And my question is, do you do it? Do you, when you use some kind of things, do you take a look? There's license under CC something, and you will then put it in Google or Chat GPT or asking your mother, hey, what's this? I don't know. Always do it. Always do it. So this is this is free, this is fine, do whatever you like. This is, hey, do whatever you like, but further continue with whatever you like with things based on this license. CC0, 0, 1, 0. This one's a cool one because these people who produced databases under this license said, we do not give a damn. We don't care. So as you can see, the example notice says, data released under CC001, no rights reserved. Who's the author? I don't know. I don't care. I created for people who can use whatever they like. There's one free license, I don't have it there, which is literally called do whatever you fucking want with this. So name of the license with all the fucking world included. So this is very similar to this type of license, CC010. So you can see, you can free use without any restrictions. No need to give a credit. Yeah, you can see. If you can compare it, here you get data copyrighted by Jane Doe. Here is no rights reserved. Also important. And applies to the database and the content, or also this license says that even the content of the database is free to be used. And the creator says, no rights, I waive all rights, or in some jurisdiction he says, I have no legal rights to this database. You can use it. These licenses you can meet also not even with databases, but you can see it and the pictures and the computer programs and the journals, literary works, many things. So this one's a safe one. Yes? I will show you why. Because otherwise you will never know what you have, because usually what you create is a combination of things. Very often you combine things and you need to know which databases are under which regime, because one part of your work can be under CCO, but another part could be CC BY, another part could be very different thing. So if you wanna regulate these things, you need to know, and you need to make a logging of it. We will get to it. It's a very good question. There are some databases that are really meant to be, some licenses that are really meant to be for databases. So this one's a very common one, ODBL. It's focused on the databases. So if you read the license, it really takes with all the things that databases are used, like to modify, extract, etc., etc. And so you can see it's very similar to CCBY. So it is a free use of the database. You can create derivative database, produce works from the data. You can produce things, the derivations of the database may have different licensing than the original database. This is a very important thing. So imagine you have a database which is licensed under ODBL. So you need to follow all these rules. But if you create a derivative work of this database, you can have a different licensing, which allows you to keep your rights. The copyleft is weak here. Of course, you need to have attribution, credit to creator, contains data, open data initiative license under the ODPL 1.0. You need to keep the open data accessible. If you publicly use and modify the database, you must also make your modified version available under the same license. It means that if you modify the database, this is an important detail. One thing that you modify the database, and you need to keep the license, but if you use the data to create your own work, it's a different regime. Is it clear? That you're changing the database, or you're using the database to create something else? Two regimes, legally different. If you don't want to use this share alike and copyleft things, there's another solution that you can use. My favorite one, of course, which is ODCBY 1.0, Open Data Commons Attribution License. Once again, you can see it's completely free. You can share, you can use it. You have attribution required. Once again, here's an example. You need to create the creator. You need to put a link to the license to your work. There's written what is the condition, but there's no share alike, no non-commercial limits, only keeping the author, which is good, which is better for you. You can easily use more of the data, which is ODCBY. And of course, the best one for you, very similar to DOC, is the PDDL, Public Domain Dedication License, which allows you to do basically anything you want with the data, with the database. So you can see unrestricted use, no attribution, full compatibility with others. Author doesn't care, you can use anything. What if? Another question for one Bludišťák. What if you have a database license under this PDDL open source license, which technically allows you to use the database whatever you want, but the database is a database of names of people, date of births, telephone numbers, names of their dogs and cats and lizards. And you see such a database on the internet. So there's PDDL. You said, I remember that guy. He said PDDL is good. So, I can use it. But it's a database of people. Can you use it then for any purpose you like? Calling them, hello, would you like my services? Or using them for your work, like saying, all these people are going to die because their temperature is 50 degrees. I found it on the database with PDDL license. Well, who thinks that he can use the data because it's licensed under PDDL? Who thinks that you cannot use the data? The rest of people think something. You have to follow GDPR and other laws. Okay, you see, the thing that there is something written there as license to database doesn't prevent you from following any other legal restrictions that you may face. So don't be, how to say stupid? So if you see a database and you think this cannot be free, it doesn't make sense to me because GDPR exists, copyright things exist. So always use your brain and thinking, this doesn't make sense to me. Because then, if you realize all these licenses that I have just shown you has one important thing that their creators provide you no protection. Why? Because it's free. They say, this is free, use it whatever you like, but if there is any trouble, any damage, any infringement, all these licenses has one important thing. We don't care what did you do to that. We don't care how you use the data. It's your problem. So if you there have filing a lawsuit that you use some personal data from database and running said, but there was PDDL there. I thought it was free to use. You will not be protected and you will have the problem. So yes, there are some free licenses, etc., but you are not protected by anyone who provides these licenses because it's free, and you always need to if you see that there's some personal data for GDPR, so use the database, but use it in a way that you are protected and you use it in accordance with GDPR and other legal rules that you need to follow. Of course, if the database is done in a way that it makes sense to you, like it's perhaps the temperature, pressure, moisture, whatever these kind of data that are not at the first glance personal data, it's always more safe. But if you see some protected things, so then be always aware and consult it. I skipped a page about the contract structures. So how you can, because even these open licenses are licenses, and if it's a license, it means it's a contract that you have with those people who are providing you the database. So it's always a contract. So what's the structure of the contract? How you can get the rights to use the database on the basis of a contract. So it will be, hello, my name is Jan Barta. Please send me the contract. I will sign it and send it back to you. And you will sign it, you will send it back to me. And we will both have 2 versions of the contract in paper. That's how you do things today, don't you? No, of course not. You have some kind of form on the internet that you fill in. You put your credentials into it, and then you execute some contract which is in a PDF, and you have no really option how to modify the contract. So you need to go through that, and you need to see those things that they have. And what would be most important for you if you pay for anything is, what is the scope of the license that you give? Well, if these are the free licenses, it's free for everything, everywhere, etc. But if you pay for it, be always watch these things. What is the purpose? How can you use the data? Commercial, non-commercial, scientific purposes, journalism, whatever. So the purpose is one of the most important things. The second one is territory. I know that the internet is for everyone except China, North Korea, Russia, and other democratic states. So always watch the territory. It can be EU, it can be Brno, it can be USA. It can say you can use it in USA. Now, today, perhaps AI, some of the AI things you can use in USA, but not in Europe. Like part of Gemini and part of Grok or whatever this is called. Some of these functions of these systems are not legal in EU, and also some content cannot be licensed to EU, or some content can be licensed from EU. So this is important. So territory. And the other thing is term. For how long can you use it? Imagine that you have perhaps a database of pictures or articles, and these individual elements are also protected by copyright, and the contract, which you don't read because it's long, it's in PDF, it's in English, and you don't like it, these legal things, says that if you don't pay extra, you can use it perhaps for 1 year or for one use only. Or, which is very tricky for some of our clients, you cannot give it to your customers, or it's just for you. It's your personal license. So you buy it for yourself, you want to give it to the university, you cannot, or the university buys the license, but the university cannot give it to anyone else because the conditions doesn't allow it. You have no agreement on some conditions. So don't feel that I have paid for it, so I can do whatever I like with the data or databases. It's not true. Another thing, warranties. So what does the database holder warrant you? The structure can be very different. It can be as is. I don't care, you paid for it, but it's as is. Or my favorite one, best effort. We made best effort to verify the content of the database. Best effort. Which means we tried. How? Somehow. Best effort. Best effort and as is, that's what all lawyers love because it doesn't mean basically anything. So once again, see that. Notices and takedowns, termination, deletions. Also, the conditions may say that perhaps that you don't renew your subscription, that you must delete all the content that you use from the database. Which means like you pay the subscription to access any data for 1 year. You used some data from the database that you've accessed. Cool, your subscription ends. Can I keep the data? Can I keep the articles? Can I keep the pictures? Can I keep the data? Or should I delete it? Or must I delete it? It's also written also in these conditions. And it's also, and you read everything from this and it's okay. So another problem that we have. If you use any copyrighted work for your work, and you have a license for that, and you want to sell your work or use your work for perhaps to give it to another person, do you still need the consent of the original author? Well, or another tricky situation. You have an article and you translated it. You use the translator to translate that article, and you want to sell it. Do you need a consent of the original author and the translator, or none of them, or one of them, or mine consent? So who thinks that both? Who thinks that only the original author and not the translator? Who thinks that only the translator? Well, once again, it depends, but generally you need the consent of all the people included, because if the translation is a copyrighted translation, it's not a DeepL translation, so it's a sort of scientific approach. If you want to translate any scientific article, you cannot be like DeepL if you want to create a good value out of it, because you need to understand. It creates some kind of scientific value to the translation. And then yes, then you would need consent of all these people. So if you're buying some content from the databases, you need to also verify whether these conditions allow you to resell it, to reuse it, etc., etc. You don't have this problem with those open free licenses because they said you can. That's why we made those standard licenses. But if you have a commercial databases, always verify it. Because usually if someone's selling something, they want to make money out of that. And why should they give you the worldwide, indefinite, super trooper license for all eternity for $1? Why? Because so you said, thank you very much, good sir, and see you later, skater. No, they want to keep the money flowing. And if you use this content of these databases, you still are following the initial rules. So if you buy something from a database and then further sell it to your customers, you still need to see whether it follows the original rules that database has. Any questions to licenses? Yes, and I will give you this, so we don't need to show.
So if there is some database or some object that doesn't have a legal notice, if there is something that doesn't have this legal notice released under this, what does it mean? Means that there are no rights associated to it, or? I have in mind, it's a stupid example, but some years ago, there was some leak from the Italian government and somebody got the list of all residents with all the tax declaration. And it's quite sensible information, and it was obtained illegally, I guess. Of course, it was not released under any license or so. What can one actually do with that data?
You can keep it, we can flow it. Well, of course, if you have an illegal database that leaked somewhere, there is like official use of this database that you will say like, great, this is a very good database to be used commercially. This is of course nonsense. But there are some licenses how to use this database, perhaps by the journalists that have a legal license to go through something for the purpose of journalism. And some scientific purposes can be, well, maybe found. But generally, if there's nothing there, that means that there's no contract, of course, but there still can be that sui generis database law said that someone invested in this database and you cannot use it without his consent. So if you found a database anywhere and there's no legal notice how to use this database, you need to consider if it's just a data set which has no significant value, and then you can perhaps use it. There's no personal data, perhaps. Or if you see that somebody must have invested to create this database, obviously, so there exists that sui generis database law which protects you from using that. So you cannot tell. I know it's tricky. Usually your like sense of common sense usually understands whether it's just a set of data that is like general or it's a set of data that someone created. I gave you some examples that how can you combine licenses. So the CCO, if you remember, CCO is the most free one. You can basically combine with anything. It's compatible. But still consider GDPR and terms of use. CC BY 4.0 and ODBL keep layers to separate our triggering share-alike on the database. Well, sometimes it happens that you have a database which needs you to follow the share-alike, and some part is like a free part. So if you want to avoid that this share-alike, this copyleft database consumes the free one, so you need to keep these databases separated. And if you have a structural set of data, so you need to use these notices that I showed you, and that how you ask, why should I keep that notice like this? So if you're going through the data set, you need to make like a bracket, or you can make some division of the databases and set this part is released under perhaps PDDL 1.0. So anyone can use this part of my work because it's already free. But the other part, perhaps by CC BY SA is licensed under this license. So if you use it, so then you need to include the share-alike conditions that if you use it, you need to follow all these rules in further databases. So that's why I said it's important to know what's the source of your data, because if you combine it, you usually cannot say that all your work is now under and pick any license that you have. If you're not the original creator, if you took parts of the databases, they should be divided, and there should be notices saying the users what is the origin of data, because even these free licenses like CCBY or ODBL says there must be attribution. Do whatever you like with that, but there must be attribution. So and this is the only thing that you can like infringe in the license, that I said, I don't care what's the license, I will use the data anyway. No, this must be there even if it's free. This is the only one condition. Good question that I hear from the background of this session. What happens if I don't do it? You will go to hell then. Or heaven, depends what is your score in your life. But shocking, I know. But the thing is that when there's no court or no plaintiff who will go against you, nothing will happen. This is because. But there are some organizations who support all these free things. Perhaps they invested money to creating a database under free license. This is very common, that you have perhaps some scientific grant, some money, which says, whatever you discover must be released under some free license. This is very common because the government, European Union wanted some data to be created and to be given free. So if you infringe that and someone finds out, they can go against you and say, hey, you've used some database and you didn't follow the rules and we want some money from you. That can happen. If that happens, please write to me, because it would be very interesting for me to have it like, how they approach. But it can happen, I've seen it. So that's why you need to keep all these notices. Well, and what if you... Usually, if you have a proprietary license and if you have a CC BY SA, it's usually incompatible. Why? Because this proprietary data, these that you have bought, usually, you paid for that, says that you cannot give it free to anyone. And that's what CC BY SA wants. Give it free to anyone and follow the rules. So combining these two data sources may be very tricky and even impossible. Or you need to make a separate distribution. Keep the data separated, have the product combined in a very different way. So it's often incompatible for combined sources. What does this mean? Of course, that if you see some data under share like CC BY SA, try to look whether there is no free solution available. Sometimes. And what can you also see, especially in software, but also in databases, or for software managing databases, that you're going on that page, and then you see that it's free. Something very good is free, and you say, hooray, it's free. The world is a better place than I thought. So, and then they have it, but you can also pay $50 for something. Say, who would the hell pay $50? It's free. Maybe some people who have too much money. Well, the reason is that some products have what we call dual licensing or multiple licensing. And it means that you can download it, you can do whatever you want with the product, but it's under share-alike licenses, which prevents you from using it with your own data, with your own products, because you cannot combine it without having it under this very nasty share-alike rule. So, but you can pay $50 or any other price to pay a better license for you, that you can use it however you like, but without these share-alike conditions, that you have a proprietary use. If you're perhaps a programmer, Linux, does anybody use Linux? Of course. Perhaps SUSE or Red Hat or these very good products. They have their community versions, which has copyleft rules. Everybody can use it. You have communities, etc., etc. And next to that, there's the enterprise, Red Hat Enterprise Solutions, which you can pay for, and it's a standard product with completely different licensing. Or some products like Grafana, maybe you know it, or Kafka, Zabbix. There's plenty of software solutions that have dual licensing, Elastic, a lot of them could be used. So be wary and always check these licenses. Well, any questions? I don't know what time is. Yes? Yes. Mm-hmm. Mm-hmm. Like you mean if it's something published, yes. So if it's something published, that you need to also follow the license that you have. You can have some free use. Well, depends if you're free using the database or the content of the database. Two different things. We will now take a look at how can you use the free use of the database, which is a law which allows you to breach something. And if you want to use the content of the database, which means a part, so the most common things that you can use freely is make a citation, which means that you can even whole parts of another work used in your work, but you always need to get the source. Most plagiarism in the world is done in a way, and well, if anyone's doing any scientific work, etc., you're always using some sources, usually you're using sources. The problem is that you don't use a citation. That's what makes you a plagiator, because if you use the citation, it's completely okay from the perspective of a law. It said, as Jan Barta wrote in his book of love and hate, here's the sun always rises in the east and sets in the west. And it's great scientific, but it's written in a book who somebody wrote, and if you don't write it there, that's your plagiator. But regarding databases, what the Czech law, well, it's a European law as well, it's the same, says how can you use DSM, it's the data mining. There's a great exception for research organizations. So if you use it for research purposes, you can make data mining of database without the consent of the author. This is cool. This is cool because this law breaches, it's a legal exception which breaches the sui generis database right. And I believe it also breaches the contract that you have with the database provider, because it's law, it's a legal exception. Without this exception, the scientific research would be really, slowed, worse, but it has to have the rules, which you said. The most important is that you're a researcher, it's a scientific research, and you need to state the source. You said, I data mined this data from this database. Without this, you cannot use this legal exception to use the database and the data inside. This is something that a lot of people forget to do, and they are very unpleasantly surprised that they don't do it. All these conditions must be fulfilled all together. This is important. It must be all together. The other thing, it's non-profit, so your scientific research is non-profit. So you're not a pharmaceutical company or something. Somebody's doing a research to create something which will be paid for. It must be a relevant part of the database. It means that you're data mining only the part that you need for your scientific research, not for like I scraped all the database and use it. No, only the relevant part. And it's a very good question that you said, that there's lawful access to the content, which means if the database is created by a data breach, which means that the data were leaked from somewhere else, they were not accessed legally, of course. Even they're free on internet or darknet or whatever your favorite part of the net is. So it means if it's there without the consent of the data holder, you cannot use it under this license. The data holder cannot prevent you from using the data. So what's important to fulfill this exception is that you have an internal citation methodology, how to do it. Said I'd use this database, etc. And you have evidence of using the database of the purpose. So if I used this, if I created some work of a database from some data, so I would make a clear, of course, citation is needed, but I would also have like a sheet of accesses to the databases that I would like verify and saying I used this data from this database, and I would make a reasoning how I fulfill this legal exception. So I use a database of National Geographic on their webpage, which is legally accessible. There's no paywall. There's no paywall for that. It's open. It's there. I'm a non-profit scientific engineer, and I used this part because this part is relevant for my research, which is bang, bang, bang. So if later on National Geographic comes, or whoever, and says, you scraped our database, so you have a clear explanation how you fulfilled this legal exception, because after 2 years you wouldn't know. So always follow all these things that you've checked, and then you can use the data in this database that it's open for you. Well, this is one exception. Yeah, there's a question.
Sorry, can I have a question? So what if I data mine a database for a non-profit research, but I use the output for a publication in a subscribed journal?
That's commercial, isn't it? Well, the law says it's non-profit. So if you're paid for that, like if it creates the output a paid content, well, a step back. All these exceptions that the law has one important condition, which is called three steps test, and which basically says that it cannot be unfair to the author. So if you use the content to create something that generates money, and the original author doesn't receive any corona, like the currency, not the disease, so that's unfair to him. That's why this exception would not work, because it's the great discussion here today about AI scraping all these articles on the internet, etc. That says all these New York Times and journals, they created massive content. Somebody scraped their data and used it for their commercial purpose, and they received no money for that. This is the very same principle that you just said. So if it's paid, so why shouldn't the original data holder shouldn't be paid?
But then it might be a problem even if I publish it to a journal which is open access by CC BY, let's say.
Okay.
But I paid to the journal, so the journal made money.
Well, of course, there are details in this process. Basically, if you are the one using the data, your aim should be non-profit. Then, if someone takes your work and uses it for anything paid, you're maybe not even able to even control it. Because perhaps you said, I use it for a non-profit, so I use it under PDDL license or CC BY license, very free one, because I got it from free, and I, as a researcher, I release it for free, but there comes someone says, I'm collecting all these free articles and putting it under paywall. It's nothing that you can really regulate.
Okay, thank you.
They might be breaching the license that you gave on the article, which perhaps said, this article must always be free. Then it's up to you, and you should release it also under very open license. But if someone puts it after the paywall, well, what can you do? And it happens. This happens, that someone's collecting free articles and putting after paywall. That happens. I think it's illegal in a lot of. Is there any time? I will like. What do we have? 10:30. 10:30. Cool. Oh God. So anyway, data takes in data mining. If you are, internet is full of databases, and of course, it would be very tricky, and the word would not work if there was no like a general exception for data mining. And we have this one, which says common and appropriate use. So imagine that you have a database of animals that somebody gathered, all animals living in South Sudan, and he made a database of these animals with the pictures and how he likes or she likes these animals and what are their sounds perhaps. So if you're a general user accessing this database and using parts of the database, I want to use it for something, the gazelle from South Sudan. That's a common and appropriate use, that you're just going through the database, looking at the data, etc. This is a common and appropriate use, and you can do it without the consent of the database holder if it's a public database. If it's not substantial part of the database, like you scrape half of the database and use it for any purpose, that's illegal. It's not systematically or repeatedly, like you have a robot who's going to the database and scraping the data for your purpose. And you cannot infringe the right of the owner. So if anyone puts public database without any license limitation, there's a plenty of databases like that, usually some web pages containing some data. So if you use it for a common and appropriate use, you can use the data. It's like the common user use of the database. Because otherwise, if this rule would not be there, it means that anyone who uses any database on the internet would need a license, etc. It's just nonsense. Normal users you can browse the internet and get the data from the databases that you found there for like a common purpose. What's okay, what's not okay? Okay examples, one-time queries, occasional citation of small snippets, text extractions. What's risky? Script. Always when you program a script that's scraping something, it's always nothing that is, as I say, okay. Small parts, because it's repeated and systematic. Usually when you have a database holders usually have some technical means which can prevent you from scraping the data. They have a document which is called robots.txt, which says the rules for the robots coming to the database or to you. And if you're scraping the data from a database, usually the database holder will see in a while that there's a systematic scraping of the data. So, but there are of course technical ways how to go around this. But usually, sometimes when you're using some database a lot, it can happen that you are blocked because the database owner and holder thinks that you're a robot and that you're scraping the data, and so you're blocked because he would not sue you, like, you're illegally accessing my data and I will call to my attorney, there's somebody accessing the database, please go to the court and we will sue them. No, they will block you in a technical way. Why would they do that? So you need to find some proxy server and do it in this way. If you want to use these exceptions, as I said earlier, please always log the purpose and scope to be able to show the proportionality of the use. So if you're using any databases for your work, apart from the licenses that you have, always state, I use it under this license. I use it under this exception from the law. I have a contract which says this, this, and that. Even for the parts of the database. Sometimes what we see in practice, that people gather the data all together, made one mix, and you will never find out what the origin of the data is. And if someone says, you used your data, the law says that you must be able to prove that you have a right to use the database. The database holder says, I am a database holder, I have all the rights, you are using my data, so prove what is the legal background of your use to the data. And if you say, oh, it wouldn't be an answer that is sufficient. So the order makes friends even in the legal way. Download the terms and conditions. If there is a page with the terms and conditions and you're using the database there, download the terms and conditions or make a print screens so you know what rules did you use. Well, as we are living in the modern world, the current law wants one thing in the European Union, that the data holders should not prevent appropriate users from using the data. One of the most important acts in this matter is this one, which is called Data Act. Does anybody know what's Data Act? Yeah, everybody knows, but to have a maybe brief introduction. Data Act is a European Union regulation, sort of a GDPR thing, which, among other things, says when there are IoT, when there are services that gather data in devices, like IoT devices, imagine any IoT device that you have. So if you are an appropriate user of the IoT device, the producer of the IoT device must provide you with the data aggregated in the device. Basically, you bought some temperature meter or pressure meter that you have in your house, or you have your smart fridge, or have a smart dishwasher, and it gathers a lot of data. All these appliances gather really a lot of data. And data access that if there is any data gathered by this device, the producer of this thing must allow you to access this data. It's a cool thing. Imagine how many data you can get from these devices. And it's a legal thing, so you can ask the producer to give you this data, and they cannot say no. It's our data, because it's your data. It's your temperature, it's your moisture, it's your pressure, it's your consumption of milk, which your smart fridge has. It's your data, and you can have access to that. And the coolest thing about Data X, it says that you can request the portability. You change your fridge producer, cool. Ask your current smart fridge producer to get the data from the fridge and get it to the new fridge. So you can continue with your milk consumption analysis in your new device. So all the appliances in European Union which uses data gathering, data mining, must be produced in a way that they can be extracted and put it to another producer. Super cool thing. Super scary thing if you're a producer of things. But it allows you, so GDPR gives you control over your personal data. Data Act gives you control over your non-personal data that you create. Because before Data Act, if you ask the people who produces all these devices, they have all information about your house, about your car. Imagine how much data is gathered by your car. You would be scared if you knew how much data the car sends, if you have connected with the internet, how much it sends to the mother companies. It's a very scary thing, especially if you're driving Chinese cars like Volvo or MG. So these are, like currently perhaps the Danish government realized that they bought Chinese electrobuses, and the Chinese government is able to turn off these buses, and that the buses communicate with the China motherland as well as like all these solar systems that everybody has on their houses have Chinese components, and the China is able to turn up the heat and make a bang with those devices, etc. So control over data is really a thing that currently is. So if you wanna extract data and data mine, use data mining from the devices. So think of DataAct, which can really help you with all these things. Of course, last but not least, the GDPR. I already said some things about that. So just a brief recapitulation. If you have a database containing personal data, you never ever can use personal data without the legal purpose and the legal background. So there are some limited reasons how can you use personal data. Of course, you can use it for your personal use, but if you use it for your work, you always need to have a legal basis, which can be also some scientific reasons, which can be, I believe, a legal basis for personal data processing. But always there's a limitation of purpose. You can also only use the data that you really require for the purpose that you're following. You just cannot all data. You cannot have downloaded data sets without the legal reason. And of course, think if you're using personal data, some people says, especially, is there anybody included in medical services here? Huh? Well, there are some data which are more protected, like your health information, perhaps. And a lot of people use anonymization or pseudonymization word. So it means that they say, I'll make some operation with the data which prevents you from making the people there to be identified. But a lot of people says, okay, so I will delete the name and the surname. But that may not be sufficient, because if the other data set, if you have there like deleting, there's a guy living in Nadžlábkem, Havlíčkův Brod, so it's me without the name, because I'm the only one living there, perhaps. So, so there may be very indirect ways how to identify people. So always like pay attention to that. So you cannot just use the information about people without really GDPR things and other like legal things. So as our session today, our data sabbat is about to end. So I would like to recapitulate some common mistakes that you can meet when using data. So the most important is that something is free and you use it because you found it on the internet. You didn't care about the license. You don't understand what all these BD, BY, SNAPA word means. So there's some kind of license, so I believe it's free. There is no attribution of the data that you use. There's no words like copyrighted by, Giro d'Italia, whatever. Missing all these things. You're missing copyleft issues, that if you use some data in your work, that all this work must be then licensed under different license. You don't read terms of use at pages, that you don't care about the territorial scope of the license. You don't see how long can you use these things, what is the purpose that you can use. So always see the terms and conditions if there are. If there is a term and condition, it has really priority over some legal things. Unclear scope of licenses, not giving clear divisions between the data sets, that you combine the data in one bundle and you're not able to see which part is from where. And of course, a lot of people use this data with like raw data about real people, and then don't use any anonymization for these data, and they are fully deep into GDPR things. So be wary. So if you use any data, always take a look at the pages, at the conditions, and follow all these rules. And then, once again, if you're using for your personal purposes, nobody is going after you. Very unlikely. The more you get deeper into commercial, the more you need to follow all these rules. Otherwise, there are people who are looking. There are companies whose business is looking for those copyrighted infringements and trying to go over you. The more commercial you go, the more you are threatened. You can use the scientific exception if you're a scientist, but there's non-profit limitation over there. So, any questions? If not, so I would like to thank you for your time. Yeah?
I hope this is the last questions I have. Because nowadays we use the AI in everywhere, okay? And AI makes the things easier. So the generally example, if I say topic and AI will source 100 or thousands of articles and show me, oh, this is the work somebody has done, blah, blah. Of course, as a user, I have to check the license, like whether I can use it or not. My question is whether AI is limited on the legal terms or any restriction to the AI, or do you have any idea?
Yeah, AI, of course, limited. AI is now in sort of like a new thing, the new big thing regime. The Czech law says that AI can use for the purposes of AI learning. They can use the things they found, basically. If there's an opt-out, so if you have a web page, because AI is using internet basically, or stolen databases and internet, that's what the AI uses. But they cannot say that they use stolen databases because otherwise they will be sued, and they are sued by the data holders, of course. There's a big, like the Danish, do you know OSA, Ochranný svaz autorský? So the Danish OSA is now suing Sora, I believe, for using the music to learn, and all these things will happen, and they are going underway. But basically, AI can learn if you don't have opt-out. So if you don't want your sources to be used for learning of AI, you need to put in the robots.txt document or in your work, I don't agree with the AI learning thing. It's opt-out principle now in the Czech law, but the Data Act, well, it would be a long discussion with that. But basically, this is what the opt-out thing is currently today in Czech law. Okay, so thank you for your time. I hope that you found some information, although it's law, interesting. And if you have any questions, you can write me an email or you can call me. And thank you for your time. And I wish you all good luck and have a nice day. Thank you.